Good morning and welcome to our online webinar on retrenchments and short time, dealing with the fallout from COVID-19. My name is Sarah Haffenden and I'm the Marketing Communications Manager at UKZN Extended Learning, also known as UEL. So at UEL, we are the continuing education unit for the University of KwaZulu-Natal, and we offer all the short courses on behalf of the university. So we are offering these webinars as we are in full support and compliance with the directive of a national lockdown issued to address the COVID-19 pandemic. So we are embracing the changes and have launched a number of projects aimed at providing free access to learning materials during this lockdown period. So one of these projects is our online learning webinars. This webinar is the last one from our 4-part labor law series. All the previous webinars can be found on our website. We will also be launching 3 more series from this Thursday, and the webinars will continue throughout May and June, and they take place on Tuesdays and Thursdays. But do have a look at our final slide at the end of this webinar for further details on upcoming webinars, or you can visit our website www.ukznextendedlearning.com. So I'd now like to introduce you to our guest speaker for today, Dr. Tamara Cohen. Tamara is a former Associate Professor of Labour Law in the School of Law at UKZN and is currently an Honorary Research Fellow at UKZN. She is an experienced labour law trainer and facilitator, a panelist of Equitate Professional Employment Law Solutions, specialising in labour matters, and an accredited commercial mediator and an admitted attorney. She has co-authored various labour law texts, including Labour Law Through the Cases, Labour Relations Law, Trade Unions and the Law, Labour Law in Context, and Laws Against Strikes, Strikes and the Law, and Labour Law, amongst others. Tamara has published many articles in the field of labour law in leading law journals and has presented conference papers both nationally and internationally. Tamara has facilitated many workshops on various aspects of labour law. So welcome, Tammy, to our final webinar for the series, and over to you.
Thank you. Well, I'm very happy. It is the final webinar. It's been quite a learning curve for me talking to myself on a laptop and not seeing a human out there. And in that regard, as far as our question and answer session at the end, we've decided that this webinar, you have an option of either typing your questions at the end, which I will then answer verbally, or if you would like to actually speak, which we would most welcome, but will certainly assure me that there is someone out there. If you'd just like to wave your hand at the screen, you'll be given an opportunity to verbally ask your question, which I'll respond to then and there. So we'll deal with that at the end of the webinar. When I came to putting my materials together for this week, the original topic was retrenchments and short time. But what I started to realize when I looked at the various options and alternatives to retrenchment out there, that there's so much more than the short time option. So I, in actual fact, changed my topic at the very last instance yesterday to retrenchments and alternatives, because this is a very big thing that many companies, many employers will have to consider, is that as part of cost-cutting initiatives, something is going to have to give due to the impact of COVID-19 on their workplaces. Retrenchment, of course, being the one option, but all sorts of other alternatives to retrenchment being the other. So I'm going to use the next half an hour or so to talk about that from a legal perspective. What can legally be done by an employer, and what procedures would have to and processes would have to be undertaken in order to comply with the labour legislation, and of course not to be in breach of contract. So just starting off, and I'm sure you are all very aware of this, I think we're all having sleepless nights about the impact of COVID on the economy. I just read a Treasury report in this last week, and Treasury has indicated that there could be as many as 7 million South Africans unemployed if this lockdown continues in one way or other for the remainder of the year. They're talking more realistically, though, that at least 3 million jobs are at risk if the pandemic is contained quickly. In other words, if we start moving on to levels 3 and 2 in the foreseeable future, and a slow recovery could see about 5 million job losses. It's no small amount considering our unemployment rates as they were already sitting at 29%. They're saying the worst case scenario could see our unemployment rates pushed to over 50%, half of our population. So there are massive concerns obviously going forward in terms of the impact on the economy. Treasury also reports that the economy itself could contract between 7 and 12% as a result of COVID, and then wages and salaries are likely to shrink. And this is one of the aspects I'd like to talk about this morning, is whether an employer could legitimately, in fact, reduce wages and salaries as a result of the financial distress it's encountered. And obviously, most of all, is company profits are certainly going to be slashed. That is, if they are able to stay afloat through these challenging times. So starting off with the hopeful, the optimistic aspect to financial distress that many companies are likely to be going through at this time. Oh, sorry, I've already managed to forget my poll question. My first poll question, and this is something that I am going to address, is the impact of lockdown on businesses. And the first question is, has your company considered cost-cutting initiatives as an alternative to retrenchment at this point in time? So if you could just enter your answers, the choice of answers are yes, no, and they may have to do so in the future. Just give you 20 seconds more to answer. Okay, so the results that I have here is that 28% have indicated that their company has considered cost-cutting initiatives. 22% have said no, which is very fortunate for their companies. And 50% say they may have to do so in the future. And obviously, depending on how long the lockdown situation continues and the sectors that are affected, this is a moving target in as far as economic impact. So if we could take that poll question down. Okay, moving on then, there are many of you that are, as employers or as employees, are going to be facing possible cost-cutting initiatives, if not retrenchments, at your particular workplaces. As I've said, it's the first step is when a company is facing financial challenges, its first step before launching full blast into retrenchment consultations, which is much more procedurally restrictive and much more onerous. Employers will initially, and I mean this is common sense, it doesn't take a labor lawyer to point this out, will have to look at what they can do in terms of cost cutting. And the first, obviously labor cost being a massive amount of a company's spend, they would have to look at what they could do, possibly in terms of changing their employees' terms and conditions of employment. Now, managerial prerogative, which is essentially employers' entitlement to run their business as they see fit, they have managerial prerogative to change their workplace practices. So if it's changing a shift time or changing an opening or closing time or tea break, anything that doesn't radically affect an employee's terms and conditions, that can be done by a manager, by employer unilaterally. However, terms and conditions form part of employees' contracts of employment, and they are binding on their employer unless there is consent on the part of employees to these changes. So in other words, employers may not unilaterally make changes to the terms and conditions of their employees' contracts, their employment contracts at the end of the day, unless they have consent of the affected parties to do so. If they do go ahead and make unilateral changes, not only is it going to constitute a breach of contract, which can be litigated through the labor courts or the high courts, and could result in consequential and contractual damages or specific performance, a restoration of the breached contract, or it could constitute an unfair labor practice in terms of, as identified by the Labour Relations Act, and which has got a specific provision that arises out of unfair conduct on the part of the employee related to the provision of benefits. And this can be referred to the CCMA, and is the appropriate remedy is up to 12 months compensation. So it is not something an employer can simply shrug off and say, well, it's my business, I'm entitled to make changes to keep my business afloat. Having said that, there is a difference when it comes, and I did speak about this briefly last week's webinar, there is a difference between a discretionary benefit and a contractual benefit. And I'll just give you an example. A discretionary benefit perhaps is a benefit that's purely within the discretion of an employer. If they've had a good year financially, they might decide at the end of the year that they will give a once-off gratuitous benefit or bonus, essentially, to their employees. That is completely within the discretion, as the term suggests, of the employer. And should they decide not to grant that discretionary benefit, and should the reasoning for that refusal to grant it be rational and justifiable and fair, then there would be no reason for, no entitlement, in fact, of the CCMA to interfere with that decision. However, many benefits are contractually agreed to. A 13th check or a performance-related bonus would be something that would be included in a collective agreement, or it would be included in a contract of employment. And that is not something that, as I said again, sorry to repeat myself, but it cannot be unilaterally changed without agreement with the affected parties. Obviously, performance-related bonuses in themselves carry a lot of complication in a workplace that hasn't been operating optimally in these particular COVID-19 scenarios, or where employees are locked down essentially and unable to perform at all. So there are complications with calculating performance-related bonuses, but the bottom line is that they cannot be unilaterally revoked or not paid by the employer without agreement. What an employer would have to do is to open a dialogue, open consultation with the affected employees or their representatives, if they are unionized, to discuss potential cost-cutting initiatives as an alternative to avoiding retrenchments. Now, as far as cost-cutting, sorry, I don't know why this is not going on. Cost-cutting options go. There are many different ones. I just had a brainstorm, and I'm not an employer, so I'm sure as employers you would come up with all sorts of your own cost-cutting initiatives depending on the particular nature of your workplace. But the generally recognized cost-cutting initiatives that have been utilized in the past are the following. There's an option of full temporary layoff, and as I've said, the definition of that is where identified employees don't work at all for an agreed period of time. Now, this can't be confused with the lockdown scenario, because this is not the same situation. The lockdown scenario, as we all know, is not a decision made by the employer or employee. In a full temporary layoff scenario, that is a decision that would be taken, a financial decision taken by an employer to perhaps shut operations or partially shut parts of their operations and temporarily lay off those employees in those particular departments or sectors or branches for an agreed period of time. An alternative to that is what is referred to as rotational layoff, where employees only work, for instance, every second week or every second day, and as a result of that, accept or have to have no or reduced levels of remuneration during that time that they are not working. Then short time, and that's more familiarity with the term short time, is where employees continue to work, but they work a reduced working day. So in other words, due to what is defined in the Unemployment Insurance Act as slackness of work, employees would work a shorter day or perhaps even a 3 or 4 day work week. And I will come back to short time and the financial and legal implications of that. Now, over history, this is not a new thing. If companies are part of a centralized bargaining unit, there are certain centralized collective agreements that have anticipated that at times short times and layoffs would be implemented and necessitated, and that and these are, for instance, the metal and engineering sector, clothing manufacturing sector, motor industry and electrical industry that already have agreements in place for possible short time and layoffs to be implemented. And if this is the case, the employee consent at plant level at the specific workplace would not be required. But in every other instance, there would have to be full agreement and consent as to this variation of working hours, whether it's short time, rotational layoff, or temporary layoff, full-time temporary layoff. But if there is a collective agreement in place, and obviously depends on your sector, then there wouldn't have to be individual agreement. This would be something agreed more on a centralized level. An issue that has come up this week with a client that contacted me about it is that they were asked to take voluntary early retirement. The question was whether they could be compelled to take early voluntary retirement or voluntary early retirement, because the implications of that is that there would be penalties with the payments. In this particular scenario, there was a penalty, if I remember correctly, of 0.25 of salary for every month of early retirement prior to agreed date of retirement. Now, can employees be forced in that situation to agree to take voluntary early retirement? And the answer is a resounding no. Without that agreement, the only option available to an employer in that situation is to commence retrenchments and to implement retrenchments, where that is one of the outcomes, the agreed outcomes or the imposed outcomes following a consultation process. Then as far as salary cuts go, there's been a lot of talk about salary cuts being necessitated and implemented. This again is an actual fact breach of the Basic Conditions of Employment Act. An employer cannot unilaterally vary salaries. This forms part of an employment contract and cannot be unilaterally varied without agreement. And the question also has arisen, must this then be across the board? Would the salary cut have to apply from senior staff and directors all the way down to junior staff? And my sense is yes. If salary cuts are going to be agreed upon by employees, this needs to be, there needs to be no discrimination in the implementation of these salary cuts. Freezes on salary increases is a different scenario. Unless there is contractual agreement that salaries will increase annually, and perhaps will even follow an inflationary increase, this is not something that's a contractual entitlement. So an employer is fully entitled to convey to their staff that due to their financial circumstances, that there will not be increases in a given year. Clearly, for a company that is unionized, they might face the prospect, and this has already arisen in a number of cases, of collective bargaining having to take place that might ultimately end up in industrial action regarding salary increases. But I think in a year like this, perhaps I hope that unions would be more sensitive to the challenges that employers are facing in this situation. And then I've also heard a lot of discussion around incentive schemes and profit-linked remuneration, where companies have really brainstormed what was originally intended in the labour legislation as workplace forums, where employees would provide some input as to profit-generating initiatives and ways to run a workplace. There's been some discussion around from employees and suggestions from employees together with employers about changing remuneration packages to a degree to link it perhaps to profit or some kind of incentive scheme to give the employer, give the company some time to get back on their feet following this catastrophic COVID scenario. Then as far as short time and reduced working time options, the Unemployment Insurance Act, and I did talk about this briefly in our last webinar, the Act makes provision for short time and for benefits to be paid for those employees that are simply being paid for short time. This was an initiative that wasn't specifically introduced for the COVID-19 scenario. It was introduced in 2018, and it is part of it's not part of the TERS benefit, which I'm sure you're all very familiar with now. The TERS benefit is delinked. In other words, it has no effect on an employee's UIF credits. This is not the same. This benefit does directly link to an employee's UIF benefits. So depending on how long they've worked at a company and what their remuneration is, they would be able to claim some form of benefit if they are placed on short time. The benefit is not enormous. It still works on the sliding scale of between 38 and 60%, depending on remuneration. And what it effectively says, and I have quoted it in bullet point 4, section 12(1)(b), says that a contributor employed in any sector who loses his or her income due to reduced working time, despite still being employed, is entitled to benefits if the contributor's total income falls below the benefit level that they would have received if he or she had become wholly unemployed, subject to that contributor having enough credit. So it would effectively be a top-up of what they are getting paid up to the amount that they would have got if they had become wholly unemployed. And when I say what they got, I mean from the Unemployment Insurance Fund itself. And there's provision for that to be paid for up to 12 months. Right, well, unfortunately, a lot of companies are going to have to think about retrenchments. I started looking for some statistics in the last week. We've got another poll question that I'd almost forgotten about again. The question is retrenchments on the cards for your company? If you could just answer yes or no, or the third option is possibly if the lockdown continues much longer. Just give it a few more seconds for you to enter your results. Okay, it looks like everyone's entered their results. Well, the winning answer is possibly if the lockdown continues much longer. 58% have indicated that this is a possibility. Yes, the answer to yes is 12% have indicated that yes, retrenchment is on the cards for their company, and 31% no. Right, so for those of you that are possibly looking at retrenchments at your company as employers or employees, I'm going to give you a breakdown of what the law says about implementing retrenchments and finally taking that decision to retrench. This is all strictly regulated by the Labour Relations Act. It's section 189 that governs retrenchments, or is referred to in the legislation as dismissals for operational requirements. Dismissals for operational requirements have got two requirements. There has to be compliance with a fair procedure, and if that fair procedure is not followed, they will constitute an unfair dismissal, which is then actionable through the Labour Court via the CCMA. But also, if there's not a fair reason, in other words, the court doesn't agree that there was sufficient substantive grounds for the retrenchment, then again, that is going to constitute an unfair dismissal. And the outcome of an unfair dismissal for operational requirements is either reinstatement, so employees are reinstated back into their original positions, which would be the ideal and primary remedy for an employee that finds themselves out of their position, out of their job unfairly, or alternatively compensation up to 12 months compensation. So again, there is very, very real reasons why employers have to ensure that there is appropriate and fair reasons for the retrenchment in the first place, and not just simply an opportunity to trim unwanted staff, and that there's compliance with fair procedure. Now, the definition of operational requirements spans beyond economic considerations. It also includes requirements based on economic, structural, or similar needs. So even if there's a requirement that the company, the employer, is in a relatively stable economic situation, but realizes that it would perhaps have to shut down a division or restructure, that too would fall under the operational requirements, procedures, and legislation. Now, the fundamental requirement of retrenchments is that there has to be consultation and what is specifically referred to in the legislation as a meaningful joint problem-solving process. And the emphasis is on the word joint problem solving. It is not something that can be done, can be premeditated, that a final decision is taken beforehand, that retrenchment needs to be embarked upon and implemented. This is something that would be an outcome of a consultation process after the respective parties, and when I say respective parties, it is the employer consulting with either the employees directly or the employee representatives, which is generally a union or unions, that have to attempt to reach consensus on, first of all, appropriate measures to avoid altogether or minimize dismissals, to change the timing of dismissals, to mitigate their adverse effect, and if all else fails, to decide on severance pay. I'll talk about severance pay a bit later, because when they talk about consultation, they're talking about improved severance pay, because the amount of severance pay, there is a minimum amount stipulated by the Basic Conditions of Employment Act, irrespective of consultation. But the emphasis is on consultation and joint problem solving. It is not a decision, and I've actually put this right down in my last bullet point, but it needs to be pointed out constantly, is that an employer cannot predetermine the need for retrenchment. There's a certain amount of background research and a background consultation with their own management to reach a point that they realize that they would have to embark upon retrenchment consultations. But the law is very clear that until this consultation process pans out and runs its course, retrenchments cannot be embarked upon. So retrenchments would commence by the issuing of a section 189.3 retrenchment notice. And the retrenchment notice needs to stipulate very clearly, needs to be provided to every affected employee and their representatives, needs to specify very clearly what is anticipated in terms of potential retrenchments, what alternatives have been considered, what numbers and timing are likely or possibility, selection criteria that anticipated to be utilized. I'm trying very hard not to use definitive terms because none of these can be predetermined, and then the prospects of possible re-employment down the line. Now, a question that's been asked of me is, can this notice be issued during the lockdown period? Is the employer obliged to wait and see when they go back to work and whether retrenchment indeed is a necessity or a possibility? And the answer to this is no. They can start retrenchment consultations during lockdown. Obviously, there's the more complicated aspect of how consultation will take place, and unfortunately, the way the world is going at the moment, it would have to be virtual. I will come back to talk about that in a minute, but yes, notice can be given during the lockdown period, provided it is conveyed and served essentially upon all the affected parties, and there is proof that this has been communicated to all those employees involved. There's no need to wait till the end of the lockdown period. Section 189.5 and 6 of the Labour Relations Act specifically points out, and it is a very long section of the Labour Relations Act, the step-by-step requirements that form part of the consultation process. And it specifically says that the employee or their representatives must be given an opportunity to make representations. This is generally written representations, and the employer has to expressly, in other words, written again, convey their response to these alternatives. And if they disagree with the suggested alternatives or the suggestions in general, they have to give their reasons for disagreeing. Again, it's not going to be sufficient for an employer to say, we have terrible financial problems, there's not really room for discussion. An employee or their representative is in fact entitled to request information, disclosure of information, so that's access to financial information, which I'll talk about later on. And the employer is required to, in good faith, engage upon a retrenchment consultation with the sole aim of both parties being to avoid and minimize retrenchments where possible. As far as, and I did allude to this a minute ago, how do consultations take place during lockdown? There's yet another new piece of regulation promulgated and gazetted in the last week, which talks about unions' access to the workplace. Now, bearing in mind, many workplaces have returned to work, but the lockdown rules, as we know, still continue. There is legislation that governs unions' entitlement to go into workplaces and consult with their members, obviously with the normal health and safety considerations implemented, but it very clearly sets out the rights of shop stewards to engage with their fellow employees and the rights of unions themselves, union officials, to access workplaces. The question that has arisen from a number of clients in this last week is, yes, under ordinary circumstances, if for instance a company wishes to restructure or to automate, they would have let's call it the privilege of some time to go down the road of consultations. Here we are facing imminent financial implosion of many companies. Can they then truncate? Can they hurry up this retrenchment consultation process? I think there is an element of urgency, obviously, in the situation. And yes, I think that the process could be truncated, but a shortened process doesn't mean that it is not a consultation process. Perhaps the time span between the union representatives reverting to the employer with suggestions could be truncated. There could be shorter time frames put in place, but there is still requirements of consultation, giving the representatives of the employees or the employees themselves opportunity to make their representations. Responding only after that could there really be compliance in the sense of starting to implement retrenchments. Another question I pose here is, does a retrenchment have to be a last resort? There's been a lot of case law over the years. Is that, can a company retrench to increase profitability? Does it always have to be imminent financial disaster in order to justify retrenchment? And the laws are very been clear on this, is that companies can retrench to increase their profitability, provided they are able to justify the necessity for the retrenchment in that situation. I don't think many of the retrenchments that are arising at the moment are directly linked to the desire to increase profitability, but certainly it doesn't always have to be a last resort. The companies might be able to anticipate the possibility of financial problems coming down the line, and they might even be able to commence retrenchment consultations to preempt that at an earlier stage. As I said, these issues will be ultimately determined by the Labour Court. All retrenchment disputes or dismissal disputes will first channel through the CCMA that will attempt to conciliate those disputes. Thereafter, it will be determined by the Labour Court, with the exception of where there is just a single employee retrenched, which will then also be determined by arbitration at the CCMA. Can the Labour Court second guess an employer's decision to retrench? The comments that I've received, and this is something that's again been raised in cases over the years, is the employer is the best person to determine the needs of their business, determine the needs for retrenchment. How can a court, standing as an outsider that is not effectively a business person, how can they make that decision whether retrenchment is necessary? That is a correct observation, but what the important point is that the court is there as the guardian of employees in that situation, to make sure that objectively, there's an objectively fair reason for a retrenchment taking place. They need to be satisfied that on the figures, on the arguments, on the information available to them, there are operational reasons to reduce their work force. And also much easier for them from a checklist perspective to be able to check that procedures were in fact followed. And as I've already said, an employer cannot predetermine this or make a final decision to dismiss prior to consultation. So I just need to see if I can get on to the next slide. Then in the case of large-scale retrenchments, and this is something that has happened already. There's been, the CCMA has already received 17,000 referrals to them of large-scale retrenchments commencing. With large-scale retrenchments, the term large-scale, one envisages massive retrenchments. It's formulaic, and it depends on how many employees there are at a company and how many employees may possibly, and this is not ultimately, but may possibly be retrenched. And it starts applying from a company that has a minimum of 50 employees. If a company has between 50 and 200 employees and anticipate retrenching a minimum of 10 employees, this is already classified as a large-scale retrenchment. So you will see that this section applies to very many companies that not necessarily considering themselves as large-scale scenarios. And this is governed by a further section, section 189A, that puts in very specific timeframes that prevent the short circuiting. And I already said that perhaps there could be a speeding up of the process, but in the case of large scale retrenchments, there cannot be a speeding up of the process. There is a minimum of 30 days if the issue is not facilitated by the CCMA, but if the matter is facilitated by a CCMA facilitator, there's provision in the legislation that the CCMA can get contacted, which has in fact, as I said, already occurred with 17,000 companies. The CCMA will appoint a facilitator who is an expert, senior CCMA commissioner, who will be given a minimum period of 60 days to engage in a consultation period, a consultation process, to try and again avoid and minimize retrenchments, and alternatively resolve many of the issues that would have to arise, have to be determined, for instance, the severance pay selection criteria during that 60-day period. Once the decision to dismiss or retrench is taken, this can either be then referred for determination to the Labour Court, or, and this is a very different scenario to an ordinary retrenchment scenario, those affected employees may rather decide to go on strike. That is a decision that has to be taken by those employees and their representatives, but it is an option that they can even go on strike. So from an employer's perspective, with large-scale retrenchments, again, it is not something that should be taken lightly. Face the possibility of the matter, first of all, be running a 60-day period, a minimum of a 60-day period, and then the further possibility of it being referred either to the Labour Court or workers going on strike. If there's an unfair procedure perpetuated in the case of large-scale retrenchments, if the timeframes aren't adhered to or the consultation process adhered to, there can also be a direct application to the Labour Court within 30 days, where the Labour Court would quickly resolve this unfair procedure itself without determining the necessity for retrenchments, which is a separate inquiry. And they, during this direct, urgent, in a sense, urgent application scenario, can order compliance with procedures, interdict the employer from dismissing, order reinstatement, or award compensation for that unfair procedure. So very, very different requirements or different safeguards are put in place by this large-scale retrenchment legislation. Another few other issues that have arisen out of the retrenchment scenario is, what if an employee has already claimed through the TERS benefit scheme? Can the employee, once they've been retrenched, then claim unemployment benefits, or is that a double bite at the cherry? And the UIF has confirmed, this is a question that I actually took off their site, and said that there are two completely different scenarios. Because the TERS benefit scheme is delinked from an employee's UIF credits, that is a completely different claim, and an employee that then finds themselves retrenched after a period that they've received TERS benefits may still then claim their unemployment benefits as if they would ordinarily have been entitled to. Then as far as severance pay goes, this is fully regulated by the Basic Conditions of Employment Act. I'm sure most of you are familiar with this, Section 41, that a minimum of 1 week's severance pay for every completed year of service is a statutory entitlement. It is not something that can be consulted over and reduced. It is something that is a right that cannot go beyond that statutory minimum. Just as the basic conditions sets maximum hours of work, and this cannot be consulted away and agreed upon contractually, similarly, severance pay cannot be reduced below that statutory minimum. So an employer that is retrenching still faces this situation, no matter how challenged they are financially, that they still have to pay that employee their accrued leave pay, their notice pay, and their severance pay. And this would have to be paid out within a very limited period of time after that retrenchment has been implemented. So what about the situation where a company has no funds? Well, I would assume that that company would, in essence, have to go into voluntary liquidation, and that would be something that the liquidator would prioritize as a preferential creditor, but that doesn't diminish that entitlement of those employees to that severance pay, as well as all the other accrued leave and notice pay that is due and payable to them. And as far as selection criteria go, the provision in the Labour Relations Act says that there has to be agreement over selection criteria, and if there's no agreement, that criteria must be fair and objective. Now, criteria such as LIFO have traditionally been used. Last in, first out. It's fair, it's objective, there's no subjectivity involved. But selection criteria go well beyond LIFO. It can become skills-based. It can become directly linked to the fact that a particular department or particular division is restructured or shut down. So there is leeway, and it certainly doesn't mean that LIFO is always the criteria that would apply, but it is very important when it comes to selection criteria that there's no subjectivity. An employer cannot then handpick those employees that have perhaps not been as productive, or those employees that have not perhaps are more unionized. There has to be objectivity. There cannot be victimization or discrimination. There has to be rationality in the application of selection criteria. So if the decision is taken to make it performance-based, there has to be an objective performance evaluation system in place in order to implement those particular selection criteria. The legislation also provides for disclosure of information. I did allude to this earlier, but as far as disclosure of information goes, the legislation goes well beyond the retrenchment context, but any kind of collective bargaining scenario, a union is entitled to ask for information, financial information, or any other information that is pertinent to the outcome of collective bargaining, and this would also apply to retrenchments. there is clearly confidential information, but the onus is on the employer in that situation to prove that that information either isn't relevant or that it is confidential, and if it is disclosed, is likely to cause harm to the company. Failing which, the employer is under an obligation, if they claim that they have no option but to retrench, that they are facing financial ruin, that is information that needs to be made available to the employee or their representative in order to justify that statement. One of the final things I'd like to caution employers about, or companies that are going down the road of retrenchments, is if there is a renegotiation of terms and conditions, employees cannot be forced to accept changed terms and conditions by means of a threat of dismissal. For instance, if a company says, and I did briefly explain this last week too, if a company says you are all going to accept a pay decrease of 6%, and if you don't accept it, we are going to dismiss you, we're going to retrench you, that is a threat that is used, a threat of dismissal that is used to compel employees to accept their changed terms and conditions. And this is something that has been earmarked as very, very, very clear breach of fair labor, constitutional fair labor practices. And it's been identified in the Labor Relations Act as an unfair, automatically unfair dismissal scenario in terms of section 187(1)(c) of the Labor Relations Act, that identifies very, very serious labor practices that are given, in a sense, the royal treatment, and that there is no justification for such conduct, for instance, dismissal on the basis of discrimination, and the compensation goes up to 24 months compensation in that situation. So if an employer is attempting to engage in consultations to change terms and conditions, it has to be treated in an open manner, and the threat of dismissal cannot be used in that situation to force those employees to accept those changes. However, there's been a ton of case law on this. The courts have recognized if there are genuine operational requirements involved, and suggestions are being made for changed terms and conditions, and the failure of those suggestions ultimately results in retrenchments, then that will not fall within the section 187(1)(c). But a causal link has to be established by the employer to show that the reason for the dismissal is directly linked to operational requirements. The reason for the dismissal is not linked to a situation to force those employees to accept those changes under threat of dismissal. So that's the end of, sorry, I seem to have lost our contact slide, Sarah, but the contact us slide with all the UEL details, sorry, has not come up, but I'm sure by now you're very aware of the contact details. Sarah, did you want to put up the final feedback poll question before we go to questions and answers? If you could just rate the session. Waiting for my results, my class mark. Okay, thank you. We've had generally very positive responses, so thank you very much for taking the time to rate the session. We now have the opportunity for questions, and I really welcome some live questions, if at all possible. I'm just going to go to the top of the screen. Okay. I see there's quite a lot of written questions. Sarah, should we start with the written questions first?
Yeah, I think that's a good idea. And perhaps if anyone wants to say a live question, they can raise their hand, and then we can also get to those people.
Perfect. Okay, so the first question, and I see a couple of hands gone up, which is great. It shows me there is a human out there. The first question from Carlo, in fact, Carlo has two questions, is are changes to terms and conditions and retrenchments two distinct processes or simple sequential steps of an overall 189 exercise? That's an excellent question, Carlo. No, they are in actual fact two distinct processes. The first process is if there's consultation to change terms and conditions. This is before the formalized retrenchment consultations and processes start. It might in fact stop at that point, and the employer is saved essentially, and employees of going down the route of retrenchment consultations. However, if an employer embarks upon retrenchments and there, as part of the alternatives, part of the consultation process, alternatives are put forward by the employee representatives or by the employers themselves as alternatives to retrenchment, these changes to terms and conditions can arise in that context, but they certainly don't have to be dealt with under the umbrella of retrenchment procedures. It is something, and in fact, I urge companies to go the route of first trying to just engage in consultation about these changes before going down the more formalized retrenchment scenario, where, and I would hate to shoot myself in the foot, but where then one starts involving legal representatives and attorneys' fees and legal costs, and possibly looking at the labor court, whereas these changes are simply contractually agreed changes as part of an ordinary in-house consultation process. So that's the first of Carlo's questions. The second part is, can an employer underpay its employees by some 50% in April and only raise poverty, in quotation marks, as a purported reason retrospectively? In other words, simply tell the employees after the fact. So can they underpay? Sorry, I just got to get that question into my head. Yes, they can do that. The poverty, in quotation marks, as you've said, might in actual fact be something that has been there all along, but they've taken the more sort of moralistic route of trying to pay their employees something instead of nothing, and they can, but the onus is on the employer in that situation not to claim poverty, to provide proof. If it is part of a formalized retrenchment scenario, they would have to provide objectively justifiable proof, otherwise it would be an unfair retrenchment. Or if it is some other basis before retrenchments, then it would depend. If the company has simply closed down, and we've spoken about this, I spoke about this in earlier webinars, they would be completely excused from paying. But if they are continuing to work, they cannot simply, if all the employees continue to work, they cannot simply then reduce their salaries by 50% or less. That is something that cannot be unilaterally changed. And the lead on from that question is what remedies do individual employees have, and how to determine whether to approach the CCMA or Labour Court. Well, first of all, everything first goes to the CCMA, but it has to be indicated in the 711 form if the dismissal arises out of that, or in the unfair labour practice form, I think it's a 713, what the dispute is about. So if it is an unfair labour practice arising out of the provision of benefits, that will be finally determined by arbitration process at the CCMA. If it is a retrenchment, it will be finally determined by the Labour Court. If it is a breach of basic conditions of employment, that would then be resolved at the CCMA. And if there is a contractual breach, there's simply a failure to comply with the terms of an employment contract, then that will be determined as a civil matter, contractual matter that can be resolved by the Labour Court or by the civil courts, the High Court, at the end of the day. So hopefully that answers Carlo's questions. Get rid of that question. Sorry, I think I might have lost a question along the way. I did see a question that I somehow think I might have deleted by mistake. What about medical aid and pension? I don't know if that person that asked that question out there wants to clarify on that question, but as far as medical aid, and I did talk about this in great detail in last week's webinar, which you can go and listen to if you have the energy to do so. But if an employer is not obliged to pay remuneration, they are also not obliged to pay medical aid and pension fund or provident fund contributions. During that period, they are not obliged to pay. If the workplace continues and those employees are still continuing to work, albeit possibly even reduced working hours, the employer is obliged to continue to pay those. They form part of benefits, and a failure to pay that would constitute an unfair labour practice. The various medical schemes and the pension schemes have encouraged employers to continue paying where possible, but have also encouraged schemes to perhaps allow some kind of holiday in payment, or to allow some flexibility for late payment or non-payment for a few months, but there's no obligation on an employee, on a fund to do so. And there is no obligation on employers, if they are not paying at all, to continue to pay those medical scheme contributions or pension contributions. Should we perhaps have a verbal question? I see 3 participants have raised their hand, and we'll come back to the written questions. Would anyone like to speak? Sarah?
Okay, I'm going to allow, I think it's Macutil. If you want to speak, you just need to unmute your...
Hi, Tammy. Lindy, we're here.
Hi, Lindy.
My question is with regard to the Section 16 disclosure to the representatives of the employees, whether how forthcoming the union then has to be with the information with the actual employees affected. Can they disclose everything, or can it be between the union representatives and the employer?
Now, that's a very good question. I don't think, and the Act doesn't specify, because they simply say this information has to be made available, and they don't go into details about just to clarify, it has to be made available to the representative union in that situation. They don't take it a step further and talk about the union's obligations. That would be something that the union would have their own internal arrangement. But I don't imagine that it would be possible for a union, for instance, to make copies of financial records and just willy-nilly distribute this to every employee. But they are under an obligation to be transparent and to convey whatever pertinent information they have to their members. There have been situations, and this in fact led to the Marikana massacre, where you have what is called sweetheart unions that are essentially in bed with employers and are not perhaps being as transparent and as member loyal as they ought to be. So yes, they are an obligation, and this is their duties as the representatives of employees to be as transparent as possible. But the extent of it, and I don't think they would be obliged to, for instance, as I said, take copies of the financial accounts and make that available, because that could clearly breach confidentiality in that situation. I hope that answers your question, Lindy.
Cool.
Okay, anyone else? And then we'll come back to the written questions.
Okay, we've also got one from John, so I'm going to allow to talk. John, are you there?
Sorry, can you hear me?
Yes.
Yeah.
Okay. Good morning, Dr. Cohen. So I just want to ask, it's quite interesting under the current circumstances. So there's been a lot of legal opinion in terms of before a company is allowed to implement short time, it should be by agreement. So mere consultation is not generally acceptable.
Yes.
However, a lot of companies do have within contracts of employment provisions allowing for short time to be implemented so long as notice is given to the employees. So there's an initial agreement to short time being implemented the minute the contract is signed. So I just want to ask the value of those particular provisions and whether or not you feel that they would be legally enforceable. So the employer could rely on an initial agreement at the signing of the employment contract to just give notice for short time. And then secondly, I wanted to understand if you feel that short time could ever be relied upon as an implied term. And the reason I ask this is because a lot of bonding councils in the past have been very flexible with their short time arrangements. 2 particular ones were MIPCO and MERBC, which basically allowed the employer to do it on a very flexible basis, so long as timeframes were given basically. So it was almost the employer's full discretion to implement it so long as they complied with the timeframes. Now, both of those, as far as I understand it, main agreements have actually fallen away. So the employers falling under those sectors are in a bit of a sticky situation now, because the main agreements that allow them to put these flexible short-term arrangements are no longer in force. So could they potentially try and rely on those as implied terms and continue following those particular procedures?
Okay, those are very good questions. I'm starting to think you might be a lawyer, but just to say that as far as agreements that are contractual agreements, employment contracts that make provision upfront for short time, that is involves a lot of great foresight on the part of employers, because yes, that means there has been agreement. The fact that employees never really anticipated this COVID scenario and didn't perhaps understand the implications of agreeing to that contractual provision doesn't take away from the fact that it was contractually agreed upon. So even provided there is a clause in the original contract of employment, that, or in secondary contracts where there's been amendments over time, then that suffices, and an employer can then, in that situation, without further consultation, implement short time. Clearly, they would be under an obligation to communicate that, but not to reach agreement on that. Then as far as implied terms go, the law is very clear about what constitutes an implied term. A term that, just for those of you that are not familiar with the term implied term, either you would have an express term, that is a written term of a contract, or you would have a term that's implied, read into a contract by virtue of surrounding circumstances or by virtue of the law. Now, terms are only going to be implied from the law. So if, for instance, you have a term that would be implied from legislation or from a collective agreement, that would constitute, by way of example, an implied term. Or you could have a tacit term where the facts of the matter around those workplace practices would constitute a tacit term. So, for instance, if an outsider, and the test is almost a reasonable outsider, went to the parties and said, but what would happen in a situation like COVID-19? Could the employer ordinarily convert to short time? And if the general understanding is, of course, in this sector, this is something that's always been done, then yes, it is a tacit term that could be read into the contract. But it very, very much depends on the circumstances. And the fact that those agreements have fallen away out of the bargaining council would place much more of an onerous duty on the employer in that situation to argue that this is now something that would still form an implied term. But if it has been a workplace practice that's been implemented throughout, up until this point, there might be argument to say this is a term implied tacitly by that workplace practice that has always been the case. Failing that, I'd say no, it would not be. There would have to be consultation about implementing short time first. And you're 100% right, not just consultation, but agreement to implement that short time. It cannot be unilaterally imposed. John, I hope that answers your question.
Yeah, thank you.
Okay, thanks. Should we go back to some of these written questions? There's more from Carlo. Carlo asks, if there's no agreement to salary reduction, is retrenchment a foregone conclusion, or does the employer still have to follow a proper 189 consultation process? Absolutely, the employer is under an obligation, no matter what, whether there is, if an employee, for instance, refuses to take a voluntary early retirement, there nonetheless has to be a full compliance set out, following the procedures set out in section 189. That process cannot be, an employer cannot say it's a foregone conclusion that we have to retrench. They've got to go step by step through the retrenchment consultation process, failing which it will be procedurally unfair, no matter how fair the reason itself would be, and that would constitute an unfair retrenchment. Next part of Carlo's question is, what if an employer specifically instructs its employees to work from home, and this is in fact feasible, but the employer subsequently says that business was quiet and simply reduces salaries by a significant percentage without prior agreement? I'm thinking of the situation where employees only get told about a material salary reduction barely 1 or 2 days before their normal payday. That's very much in breach of the legislation. If employees have continued to work from home remotely, it doesn't change the fact that they have been working throughout the lockdown period. As a result, they're entitled to their full payment. If there's been agreement that they would only work pro rata a part of their day, then certainly there would be pro rata obligation on the employer to pay for that reduced working hours. But failing that, the failure of an employer, or after the fact decision by the employer to reduce salaries unilaterally, would again be a complete breach of contract, would be a contractual breach. It would be a breach of the Basic Conditions of Employment Act. That would be something that the Department of Labour would pick up. And if it was interpreted as falling under benefits, it would also be an unfair labour practice. That cannot be done. There simply would be a complete breach of law. Okay, so that's Carlo's questions are answered. And then, sorry, let me just see. Oh, there's a million questions. Sorry, let's just go up to the top questions. I've got Cindy's question. What are the best practice time frames between notice consultation, response by employer, and the decision to retrench in a small-scale retrenchment, so that it does not appear predetermined and fully considered? There are no best practice time frames. I know that clearly you cannot do this entire process in a 48-hour or 72-hour period. There has to be a genuine joint problem-solving exercise, where the various parties are given opportunities to make representations. Where those representations are responded to clearly depends on the size of the company, the nature of the business, the number of retrenchments involved, but it is not something that can be truncated. Clearly, it's not the 30-day or 60-day statutorily determined timeframes as set out by the labour legislation, but there is no specific timeframe scenario otherwise. Okay, so that's Cindy's question answered. Carlo, again, does the Disaster Management Act supersede any pre-existing legislation? What is the status of the LRA and Employment Equity Act? In other words, does the Disaster Management Act trump any of these provisions? No, they are completely separate, parallel provisions. The Disaster Management Act simply obviously manages. Sorry, this is very un-webinarish of me, but my battery is about to run flat, so I'm relocating myself. Sorry, I'm here. You just got a new view of me now. No, the Disaster Management Act, as I said, is simply setting out the rules regarding handling a disaster at the workplace. It doesn't deal with any labour legislation whatsoever. The Constitution is very clear that nothing can effectively supersede the legislation that enforces fair labour practices. So no, you say that the reason for asking is because of the regulations specifically state that employees, I'm glad you asked this question, employees over 60 must either work from home or remain at home, and this applies across all sectors and all levels. In the construction industry, most of the site supervisors cannot work from home, they have to be on site, but in terms of the regulations, the employer may not allow those. If I could just clarify this, I've been asked this on a dozen occasions. What the regulations say is that over 60 are cautioned about the greater vulnerability of them at a workplace, and that they are encouraged to work from home. If you have a look at the specific wording of the Disaster Management Act, it isn't prescriptive. It doesn't say that those over 60 have to work from home. They're encouraged to work from home if they can, or remain at home if they can, but it is not prescriptive. And there are very many clients have advised that if they put in health and safety, which they're obliged to, but perhaps even more stringent health and safety requirements and safeguards at the workplace, those over 60 can go back to work. Obviously, it depends very much on a sector and a bargaining. If there's a bargaining council in that sector, they might send out other directives that vary the general regulation, but as it stands, it is not completely prescriptive that those over 60 cannot go back to work. You do go on and say, what about, let me just go on with your question. What options does the employer have? Does the employer retrench employees over 60? Is this not discriminatory? Yes, it certainly is. And alternatively, is this a supervening impossibility of performance? So as I say, if it was completely prescriptive, the bargaining council said there is no choice, this is what's been decided in this particular sector, yes, that would constitute a supervening impossibility of performance in that situation, and the no work, no pay rule would apply, but it doesn't simply mean that then they can be terminated or that they can be retrenched on that basis. They would just effectively be suspended by this supervening impossibility, but that is not the general interpretation that has been taken, that workers over 60 cannot return to work in that situation. Okay, let's leave Carlo's questions. Catherine says, if the employer pays 50% of salary, and what then? Will the employer be obliged to pay pension and medical aid? Okay, that's a good question, because if they pay 50% of salary, theoretically they're only obliged to pay 50% of pension and medical aid. So they could make a pro rata contribution in that situation. But the logistics of that might become more complicated. But their legal obligation is that they are then only obliged to pay 50%, because pension and medical aid has been interpreted as forming part of a remuneration package. So they wouldn't be able to take away the pension and medical aid contributions and just pay salary in that situation. And Grant's apologized for leaving, sorry, and has gone. So thank you. That was not a final question. Are there any more verbal questions that anyone has before we leave the webinar? Sarah, do you see any other verbal questions?
No, there aren't any more at the moment. So I think we can close off. So
No,
thanks.
that's the relocated me that had to run for electrical cable halfway through.
No problem. But thank you so much, Tammy, for working with us on this labor law series.
Absolutely.
So congrats on your first webinar experience.
Thank you. I think I've aged 10 years.
Yes, and thank you for all the valuable information that you have shared with us and all our attendees. I think it's been quite helpful for a lot of them. So yeah, the videos and the slides will be available on our UEL website, and we will be sending out a direct link to this probably this afternoon. So thank you for all of our attendees for joining us and making this webinar a success. And please do take note of the upcoming webinars. You need to RSVP to secure your place. The next one is taking place on this Thursday on immunity, nutrition, and COVID-19, separating facts from fiction. And then next week, we will start a series on resilience through mindfulness, and this will be an introduction. Yeah, so we also have a few online courses that we are offering for free during lockdown. So we're sharing some of our own courses as well as partnering with organizations in order to provide free access. So please do visit our website, www.ukznextendedlearning.com, to see what we have on offer. Otherwise, we hope that you enjoyed the session, and stay safe, and we'll see you next time.